everyone, I'm Shilpa, founder of BeGig. At BeGig, we are on the mission to connect global companies with top tier Indian tech talent.
And I'm Suruchi. I'm a lawyer. I have been working in the space of labor and employment laws for past 12 years.
So Suruchi and I were talking about where the gig economy is going and how our labor laws in India are going to affect the future of this industry. And we wanted to share some snippets from legal standpoint. So Suruchi, what do you think? How are gig workers classified today?
So, gig workers, from where we stand from a legal perspective, are more like freelancers. They do not come under the category of employees, and they are ones who decide what work do they want to pick up, where do they want to pick up work from, how much time do they want to give the work, and they have skill sets which they explore and provide their services to. So it's more like a service based contract where you provide services at an arm's length without being under the coverage of the definition of employee under laws.
I think you've brought out a very interesting point where you say that they have to be at arm's length.
Yeah.
Right. So, broadly, if you have to tell us, what are the laws saying today with respect to freelancers and gig workers?
So there are no laws. There are no laws which are currently governing or regulating the relationship of an employer with a gig worker.
Yeah.
We will soon have them, but at this point of time, all the laws primarily cover employees. Whatever is the definition under laws, whether it is for any kind of dispute, which is the Industrial Disputes Act, where even severance is guaranteed, or if it is any kind of benefit for that matter, such as provident fund or gratuity, they all only cover employees. So gig worker comes out of the definition of employee and does not get the benefit of these laws. That's why they are very unregulated sector at this point of time. In fact, interestingly, even domestic help, they come under unorganized workers. So they are still protected under the Unorganized Workers Act, but not gig workers, because they do not fall in any of these categories.
So, with the example of house workers, right? We spoke about blue collar economy, but there are a lot of white collar jobs coming into freelancing, right? We see a lot of companies hiring gig workers. For example, in our platform, we see companies hiring tech freelancers.
Yeah.
With that, what do you think companies should have in mind while engaging with freelancers, and what are your suggestions around this?
So I'll just circle back to what you and I discussed, that all of these engagements fall outside the purview of an employee's definition and at an arm's length basis, because clearly the employers are hiring them for a very specialized skill or a very specialized service. When you do that, when you do hire a person for a very specialized skill or very specialized service, you are allowing them to work the way they want to. The whole purpose of hiring anybody for a specialized skill is that they know what they're doing. The employer does not need to tell them the minutest details of how the work needs to be done, which is what sometimes happens in the case of an employee. If I have a very regular employer-employee relationship with somebody, I tell them this is how I want the work to be done, this is your timeline, this is what you will give me, and then we will review it and we will send it out to the client if it's a client servicing sector. But when it comes to gig workers or freelancers or service-based, contract, workforce, they cannot be micromanaged. That is something that the employers need to bear in mind. There are a lot of, so courts have obviously dealt with a lot of these situations, not from a gig worker perspective, but before the gig economy took like a huge rise in the market, there were also contract workers, contract labor, there were consultants and contract-based employees, and a lot of these things sound very similar but have a lot of different connotations. So when the court came up that how do I determine that you are a contract-based worker as opposed to an employee, because a lot of people, what happens is when employers engage them, they supervise them at every step of the way. So one test became, is your employer supervising day-to-day operations of yours minutely? Me giving instructions to you overall generically saying that this is how it needs to be done, that's still fine, because at the end of the day I am the service recipient. I will want the service to be given to me in a certain manner. But how it is to be done doesn't need to be told to them. What needs to be done needs to only be told to them. When I start doing that, I am edging towards that person seeking employment with me. The second test which courts came up with, how integrated is the person in your system? Are you giving them ID cards which say that this person is working with you?
Yeah.
Are you giving them email IDs which puts your domain name at the back of their name? What does their signature in the email look like? Are they completely coming out and working from your premises? Are they getting your assets? Do they work out of your own laptops and your own desktops? The moment these few factors also come in with micromanaging them, the test of integration and the test of supervision gets satisfied. Then you have to also see, are all these things satisfied holistically in one person? That person can come and say that I have been working with you for a while, I feel like I'm your employee. I'm entitled then to all the benefits which an employee should be getting. That is the area where risk increases. So when companies engage gig workers or contract based workers which are only providing a service, the company should bear in mind you're not micromanaging them. You're telling them what's to be done, but you're not telling them how it is to be done, because let that person who has the expertise do it in that manner. Yes, you may set a deadline that I need the 50% of the task to be completed by say 2 weeks, the remaining 50% to be done by the next week. Of course, you are a service recipient, that much is still fine. But when I start saying that every day how much percentage has been completed, I am micromanaging them. If I give them IDs which clearly say my name, there will be an impression in their mind that I am their employee. If I ask them to work out of my premises, it will look as if I have hired them only for my premises. Whereas a freelancer can go work for anybody. They are a freelancer. They have the liberty to work with anyone at whatever time and spend how much ever time they can. So the companies need to bear in mind they are not micromanaging. They're not integrating into the system. Of course, one test is not only one thing happening. Like if I say, for instance, because I'm also protecting my confidential information. If I'm giving that confidential information to the gig worker for the work to be done, say for instance in IT, I give them maybe my pamphlets, my brochures, some plan which I want them to use as a base draft and then work off another plan, or some code I want them to use as a base code and work off another code. That proprietary information I may need only to pass through a channel which I can at least oversee through my IT network as well. Yeah. Giving them that email ID, I will have to make sure still that email ID is very generic in nature. Nothing with their name. Say for instance, freelancer at so and so domain name. If I put their name, domain name, and give them an email signature also which doesn't distinguish them from an employee, I am creating a risk for myself. But I'm creating one risk. If everything comes into play, only then will they get benefits. Because right now they are not getting any benefits. There is a judgment in the Supreme Court, not a judgment, there is a case going on in the Supreme Court which is for these kind of things only, where the freelancers have now started feeling, because clearly there is integration going on in the industry, right? There is supervision going on in the industry, so they are saying that why aren't we entitled to all these benefits? Because of these reasons. So whenever we are engaging them, we need to make sure that we don't engage them the way we would rather engage an employee. In fact, the Industrial Disputes Act is the one which governs blue collar employees and was with the whole agenda of protecting them from being violated, their rights being violated and all. There is a specific item under the unfair labor practices which says that engaging somebody as a temporary, casual, buddy worker with the view to deny them permanent employee benefits. So if I engage a freelancer but treat them as an employee but do not give them employee benefits, that is where I am calling for a challenge. That is what I need to bear in mind.
And as a company, can you really restrict a freelancer to not work with competition? Or can you have that condition?
See, technically no, because anyway, so it completely depends. Competition, working with a competition is something that you may want to restrict when you're employing a person. To a consultant or a service provider, it becomes very difficult, because then you are making the consultant or a service provider or a freelancer give you exclusive services. That again goes back to the whole tests of integration. If I'm giving you exclusive services and I'm not allowed to work with anybody else, I completely understand you want to protect your confidential information, but if you're not allowing me to work for somebody else, you're still somewhere giving me that feeling that I'm a part of your company and nobody else. So there is a way to probably strike a balance with maintaining your confidential information, maybe restricting to a certain extent where you work with the competition, how you work with the competition. But there cannot be a full embargo on it without calling the whole employment relationship into question.
I think that's one of the most important aspects companies need to look for. And with that, Suruchi, I would love to hear your thoughts on where you see the future going with respect to gig workers, and how are legal laws going to protect them? Do you already see where the industry is heading?
Yeah, I think the government has realized, especially since the pandemic, that this economy is on the rise. People sitting from home, especially like tech, tech workforce, which is able to work from home, and women workforce, which has now again come back into the workforce with a vigor. This is on the rise, which has led to, in fact, the whole agenda of the government was also to overhaul the archaic labor laws, which somewhere were more towards the manufacturing sector and weren't towards the services sector, are now leaning towards more striking a balance between the service sector and the employer. Like the Social Security Code is the one which now will talk about gig workers, platform workers, to protect them, because they do realize that this economy is on the rise. The code did come out in 2020, but it hasn't been fully implemented yet because they're still waiting for the state rules to come about. Once the state rules come about, there will also be certain regulations and schemes which will come about. It is yet to be seen how much protection they will get, but yes, I do see that tomorrow this sector is going to become highly regulated. What all will they get? How will that be calculated? Do they get prorated calculations? Do they get basis whatever piece rate do they get? Because a lot of these workers are piece rated workers, project rated workers. They get one lump sum for a project, or they get one lump sum for per KRA that they've achieved or something like that. How it will all be calculated and how it will come into play while calculating the social security contributions is yet to be seen, because we do not have any clarity on that. How will the authorities view? Because they will need to also register themselves on a portal. They will become regulated sector, and then the authorities will have the full control in seeing whether the laws are being complied for them. But everything is right now up in the air, and when these laws will come into effect, we are hoping maybe July, because all the even the new labor the criminal codes have been made effective by July. We are also thinking that maybe something similar may happen with labor codes, but states are yet to notify all rules. Once they do that, we'll have more visibility.
I'm very positive myself on the fact that the moment there are clear labor laws in India, more and more people are going to become full-time freelancers. They'll be very comfortable to make this as their full-time choice and go all in their careers of freelancing. Thank you so much, Suruchi, for all the insights that you gave us. I think all of our clients, freelancers, would have taken something from this legal standpoint through this conversation.